I am very excited today to be speaking with Bruce Benson, who is a distinguished economist and a legal scholar, and most importantly, the author of The Enterprise of Law, Justice Without the State. There's my copy there. Bruce, thank you so much for talking with me today. It's a real pleasure.
I'm looking forward to it.
The first question I wanted to ask you is, what is the law? Do we need to have a state setting the rules of the game, as it were? It seems that most people seem to think you can't really have law without the state. That seems to be their intuitive understanding of things.
That's also a lot of scholars' definition of law. They define law as a product of the state. And so if that's the definition, then we have to have a state for law to exist. But if what we want to think about is a set of rules and governance arrangements, including adjudication, methods to change the rules, and incentives to recognize the rules, then we don't need a coercive government. There's all sorts of examples of private governance arrangements that existed historically and that exist today. I call it law, but
yeah, exactly.
If people don't want to call them law, we could call them justice systems. That would maybe alleviate some of the problems.
And that is what I love about your book, is that you look at these private systems of law, both historically, and then you make suggestions as well as to how these systems could function in the future, and showing also empirically why that would be more efficient, as well as being more moral from a libertarian perspective as well.
Well, that's what I'm trying to show anyway.
Yes, well, there we are. I think you do it very well. Please, if we could discuss briefly, obviously as an American, you are tracing your own country's legal system back through the Anglo-Saxon common law, which you have received from English law, and you take things even further back. You look then at the Germanic customary law, and you analyze how customary law comes into being.
I really start out by looking at relatively recently studied customary law systems, studied by anthropologists, described in detail. Customary law systems are not like government law systems in that they don't necessarily record everything. They don't. Judicial opinions don't get written, and so on. So it's hard to convince people there's actually something there unless you go in and observe it. And that's what anthropologists do, of course. So I try to provide a picture of customary law as anthropologists describe it, and then go into our Anglo-American legal process, and certainly it's widely recognized that the Germanic tribes had customary law, and that it was carried to England by the Anglo-Saxons. The customary law typically involves a community, of course, that has various reciprocities. They do a lot of things together. The tithing in the 100 in Anglo-Saxon England, for instance, people had obligations to respond to the hue and cry. If one of them was victimized, the rest of them went after the bad guy. They also work together to round up stray cattle, to keep their roads and paths clear. They were obliged to participate in the hundreds court if there was a dispute involving a member. So these communities are multi-dimensional. There's all sorts of interactions in them, part of which is law. But if you fail to live up to your legal obligations, you're out of the community, and you miss all that other stuff as well. So from that, of course, there is a reciprocal duty to assist each other in a legal situation. The reputation, it becomes very important in these kinds of arrangements, because if you don't live up to your promises, if you behave opportunistically and so on, other people aren't going to want to deal with you, and you can be ostracized from the community as a whole. The threat really behind customary law is violence, just like it is behind any legal system. There is a threat of retribution, but most customary law systems override that threat in the sense that instead of immediate retribution, the community expects people to go through the procedures of dispute resolution, nonviolent dispute resolution, and then if the offender accepts the judgment and pays retribution or compensation, then the individual essentially buys back the peace, as they would say in Anglo-Saxon England. So you can substitute payment, restitution for retribution, and in well-developed customary law systems, the first obligation is to accept peaceful dispute resolution. If the party doesn't do that, then you turn to retribution. And so you end up with a system where victims are compensated, either that or they take retribution, which typically includes confiscating the other guy's stuff, so they get compensated anyway. And the punishment in the sense of imprisonment or harsh physical punishments are typically not very relevant, because either the individual buys back the peace or he's ostracized. He's out of the community, which means he's fair game to anyone, and he's probably dead. So you don't need prisons. You don't need the kinds of physical punishment that we have seen over the centuries. The individuals, of course, can refuse to pay, and they then that's when the blood feud sort of sets in, which a lot of people think of customary law systems as feud law, but there are significant procedural rules in these systems that try to put off the feud, prevent the feud from occurring. The importance of payments, restitution, then also undermines the incentives to take revenge, and so they tend to be relatively peaceful within the community. A lot of people say, well, if you look at tribal societies, they're always fighting each other. Well, they're fighting other tribes or other clans, but within the community itself, it's a pretty peaceful environment. Anything else that I missed there? I was trying to think of something else that
No, I
might.
don't think so. I think that's a good explanation. I suppose I'd also like to talk about whether you think that in particularly the Germanic customary system, whether we can say that they had a rule of law as such. I think that typically, I suppose the conventional view is, well, the Greeks invented the rule of law with their communal small democracies and their city-states. But it seems to me that since going back to the times of even the Indo-Europeans, they had an egalitarian aristocracy, and so there was the leader, the king, if you like, was only ever a first among equals. Any of the others, the aristocrats or lords or whatever, could always bring the king to their court or take into account, if you like. What are your thoughts on that?
Certainly, in a true customary law system, in fact, there are leaders, there are individuals who serve in various capacities as judges, perhaps, or as war chiefs or something like that. They typically, though, rule by consent. They convince others to follow them, and if they mess up, if you take a group out on a raid and a bunch of people get killed, you're probably not going to be a war leader the next time something comes up. So they lead, they persuade people to follow them, and they maintain followers by doing a good job in meeting what the followers expect. Native American on the high plains before the arrival of the Europeans, a war chief that led a successful raid, when he supposedly everything belonged to him, but as soon as they got back to the village, he gave it all away. And then, of course, there's a reciprocal obligation to give back, and so you get the kinds of so-called gift exchanges and things like that go on. But you had to satisfy the followers if you're going to retain your big man status. Now, in Anglo-Saxon England, of course, if you think about the man price system, which essentially distinguished between the upper level aristocrats or leaders, whatever you want to call them, and the common man, so that the more important people got bigger payments of restitution. Of course, if they were the bad guys, they made bigger payments as restitution as well. And so they were all part of the system, and the system reflected their status. You could lose your status, of course, if you didn't retain your access to the community, your willingness to support the community, and those sorts of things. So typically in a customary law system, these people that achieve leadership are smart, successful, perhaps wealthy, charismatic oftentimes because they're convincing people to follow them, and generous. Generosity is a highly valued reputation because the rest of the community likes to see it, and so those are the typical characteristics in a customary law system of a leader.
Something else I'd like to ask you about, you don't go too much into it in your book, I think you mention it in passing, is the sort of system that they had in Iceland and Ireland, which was a lot more contractual, if I'm correct. The Germanic customary system, which had become very influenced by Roman law and the church, perhaps. The relationship really relied on oaths between a vassal and his lord, and then the king above him, which really made up the feudal system. But you say in passing something that was an even more complex private law system was that was used in Iceland and Ireland, where they didn't have a king. And particularly in Iceland, they fled from the king and from that kind of oppression, and tried to privatize their law, contractualize, if you like, things as much as possible to attain liberty, basically, for freedom. What are your thoughts on that, the Icelandic system? I know David Friedman has written quite a bit about it. I'd just like to hear your thoughts on that.
I really first started thinking about these ideas when I read Friedman. He, of course, has a paper on the Icelandic system. The Irish, I think, are probably more like the Germanic arrangements than Iceland was. Iceland was settled. Of course, there was no one there when the island was first discovered by the Norwegians or Vikings or whatever you want to call them. So the first people there simply claimed homesteads, including land that they could cultivate and land that they could run their sheep on, mainly sheep. So subsequent arrivals would claim other pieces of land. No need for conflict over land because it was abundant initially anyway. Then as time goes on, of course, there's more and more interaction between these farmers who some of whom get wealthy, some of whom have bad luck and so on. But they formed communities and essentially a system of local districts, I guess you could call it, developed. They handled disputes, problems internally if they occurred, but they then developed a fascinating system, I think, called the Althing, where everyone, or at least representatives of every district, would gather once a year. They had a law speaker who would stand there and recite the rules, but no executive. They had a legislative kind of process where they could, through agreement, change rules, but no executive to enforce the rules. The incentives to obey the rules essentially were the same as those I had described before, with the threat of ostracism and or violent blood feud, creating incentives to pay restitution, and of course, Vikings have a reputation for a lot of violence, but the Icelandic arrangement was probably more peaceful than many of the other arrangements in Europe at that time. They were ultimately, of course, the Norwegian king did gain control of Iceland, but they had this commonwealth, as it's typically called, for something like 300 years, 200 to 300 years, with reciprocal arrangements at the local level, and then the cross yeah, unit arrangements going through the Althing. The Althing, they had they held their court at the Althing too, with when disputes between different groups arose. So it was a more structured system, perhaps, than we think of as customary law. The districts became well defined, and they stopped creating new districts at one point, so there was a set number of districts. And But leadership was again similar to a customary law arrangement. The wealthy, because they were successful and probably intelligent and so on, tended to be the leaders. But through acceptance, through consent, rather than through coercion.
Yeah, I think it's a fascinating system, especially when you compare it with the more Germanic customary system, because under the feudal system that you had on the continent, people were still relatively free in that if they had an oppressive lord, they could move and serve under a different lord, and that lord could even take that person to court if they're breaking certain laws, they're oppressing their people. But with the Icelandic system, if I'm correct, they people weren't bound to a lord in terms of geography. Through contract, they were able to make a contract with a certain lord, wherever they happened to be, who they favoured the most, and that created a kind of competition. Which of course led to them treating their people better, seemingly.
Yeah, one interesting thing about Ireland was that the arrangement, the competition for leadership heated up, I guess you might say, with the arrival of Christianity, because individuals could, if they could claim a position as a religious leader, have a church, then others were obliged to pay them a tithing. And so it becomes more valuable with that arrival, and you get more intense competition, the potential for violence, and calling in the Norwegian king to help out, and
yes.
So
I think, sorry to interrupt you, but I think that's pretty much what happened to Iceland, isn't it? That a lot of people will say, oh, see, Iceland is an example of how a private law system doesn't work, and it falls apart. I mean, it's lasted longer than the US has so far, so I think they should hold that thought. But nevertheless, we can see that it wasn't that case at all. It was the fact that they didn't privatize enough, because they had this tribal assembly, which wasn't really a private thing, that was more of a customary thing, and they could legislate. When the church came along, they said, okay, the church is going to have no taxes on their land, so they gave them a very privileged position. And then the lords suddenly wanted to have their church on their land. They put a family member in the position of the church, and their wealth started to be disproportionate with other people, reduced the competition, and ultimately led to terrible feuding.
Another these religious chieftains within a district, those positions became marketable. You could sell your chieftainship, so you started getting concentration of chieftainships in a smaller and smaller number of hands, and so you get that sort of centralizing process, in part because they fixed the number of districts, so you couldn't start a new district if you wanted to. And so there wasn't the potential for competitive entry that may have prevented this gradual decline of the arrangements.
And in your book, I love your discussion of how a more authoritarian law, rather than a more voluntary system of law, came into being in Europe. And again, you focus more on the Germanic customary law. Am I right? Is my thinking right in saying that it was primarily this monopolizing of the judiciary, and of course that led to the creation of a state, if you take the definition of a state to be a monopoly over ultimate decision making or judicial decisions. Is that the case?
Well, certainly you get a buildup, I guess you might say, of military power and activity, in part because of the Vikings and the constant raiding. But once the raiding stopped around 950 or something like that, I think, now you've got these military guys with nothing to do, and so they start turning towards suppression of the local community in order to extract taxes or rents or something from the local community. One potential source of revenue that they spotted fairly quickly was the legal process. So you get a payment, for instance, going to the Lord, the king, whatever he was, if he had to step in and help pursue prosecution of somebody. So it wasn't any longer just restitution, but a restitution and a payment to the king. And of course, everyone in England had a piece, essentially the property rights associated with their household. And the king had a piece too, but he started defining more and more things as violations of the king's peace, so he could claim the restitution. So he says, you violate a rule during one of our celebrations, Christmas or whatever that it was. That's probably before Christianity, but anyway, one of those annual celebrations. That's then you're violating the king's peace. Then there was the king said, I'm going to represent strangers who are victimized. So merchants or somebody like that traveling through an area who was victimized, he was going to represent them. Well, what that meant is that he was going to collect the restitution. The stranger wasn't going to get restored, but the king, as expanding king's peace, would collect the money. And so it became really a revenue-seeking instrument for the lords and the kings, as restitution became less and less relevant, at least true restitution to victims. You get a lot of resistance. It took at least 100 years before the resistance to the expansion of the king's peace to disappear, and really it never did disappear, because one thing that happened was with the end of restitution system, of course the incentives to pursue offenders declines pretty dramatically. And the king found out that the locals didn't want to just go after somebody in order to collect money for the king. And he had to then try to force them to engage in these policing and prosecution activities with a whole series of declarations about fines for the community if they don't pursue their policing duties. They created the Frank Pledge system, which essentially was a replacement for the tithing and hundred. And it never worked very well. And so he had to continually impose more rules on the locals, trying to force them to carry out these legal functions that they didn't have incentives to carry out. And ultimately, several centuries later, you end up with public police and public prosecutors and all those sorts of things. But you can really trace that development back to the early accumulation of power and expansion of the king's peace.
My thinking is that we still have the same sort of oppression that you're talking about, but the king began engaging in the form of criminal law today, to some extent, because whereas before, under a private system, disputes would have only been between individuals, let's say. As soon as the king stepped in and said, no, actually you're interfering with my peace, that then began to develop into what we have today, which is criminal law. We say there's been an offence against the people, and the people are having to pay. If someone is found to be a criminal, they will go to jail, and the person is having to pay in taxes in order to sustain and to let this person enjoy free TV and all the rest of it in jail. And that seems very similar to what the king was doing there. So you're saying basically that authoritarian law, the state, the judicial monopoly, came about simply through exploitation of the people, taking advantage of the legal system?
Yeah, that's my contention. The first use of or discussion of crime as a concept in England really was during Henry II's reign, and the distinction between crime and civil matter was who got the money. So the king got the money if it was a crime, the victim got the money if it was civil. So there was a constant fight over what should be civil and what should be criminal. And of course, another thing that occurred as the king's peace or criminal law was expanding was in order to probably placate the victims who were getting nothing really, and actually having to spend time and effort to carry out prosecution. The crown started imposing harsh physical punishments on criminals. So you move from a system where you could buy back the peace to a system where the king collects your money, probably seizes all your property, and then does something really nasty to you as a criminal. And of course, prisons didn't develop for a long time. There were debtor prisons, but that was to force people to pay debts. Prison as punishment didn't develop for centuries. But you really had to have a pretty dramatic revolution in public finance, I guess you might say, to shift away from law enforcement being a source of revenues to a process where it's paid through tax revenues now. And part of that, of course, if you move forward to, you had a period where essentially every crime of any consequence was punishable by hanging or capital punishment. Minor crimes, very minor crimes, could be punishable by branding as a thief or whatever. Well, the juries that developed just refused to hang everybody that was accused of sometimes relatively relatively minor crimes, and so you get this jury nullification that ultimately forced the government to do something other than capital punishment. And so what they did is start transporting criminals to colonies, some in Africa, North America. Then after the American Revolt, they during the Revolution, they had these ships sitting on the Thames River, hulks they called them, where they just stored these people that they expected to be able to transport. But they, it took a long time, and more and more hulks, and so they started putting them in striped uniforms and all these sorts of things that we start associating with prisons. And it was started costing them money. Finally, actually, the transportation early to North America didn't cost them anything because they franchised it out. They let private merchants haul these people to America, and essentially they were indentured servants that he could sell the indentureship to somebody in America. So the king didn't spend any money on that, but when they had to ultimately start transporting to Australia, that became expensive, and the government was paying for that largely. So now at that point, there's kind of a shift from government not paying anything really for criminal justice to being forced essentially to pay something because they couldn't get the juries to hang all these people, and they no longer ship them cheaply to North America, and so you start seeing a willingness on the part of Parliament to spend some money, and after that, it's still several decades before they actually start building prisons, but the process was one of pretty dramatic impact as we moved away from a virtually costless system, to the government at least, to a very costly system that we have today. I still argue that we can think of criminal law as a revenue-seeking process. I mean, there's still huge fines being charged to corporations, billions of dollars and that sort of thing. And in the U.S., at least, we have these towns that finance 2/3 of their budget from traffic tickets, and of course now we have civil asset seizures, which means that police can seize property without even charging someone with a crime, just simply allege that the property was involved in a crime or purchased with criminal proceeds. Huge amounts of money being transferred to the police. Of course, the other part of the revenue seeking then that I argue is still going on is that these various public agencies, police, prisons, so on, are competing for budgets. And so their incentives, of course, are to have lots of laws to enforce and, uh, you know, big budgets so they can then claim to be trying to enforce all these laws. So now in the U.S., people are talking about over-criminalization. We've got so many crimes that most people commit a crime or two or three every day.
Mm,
Don't even know it
yes.
in a lot of cases.
So the basically the king's way of doing things didn't really help the people who before were getting their restitution. In
Mhm,
fact, it just became more and more expensive, and the taxpayer was having to pick up the tab.
mhm.
Whereas before, ostracism and debtors' prisons were working okay,
Uh,
and
yeah,
really
they were
we've
asked.
got a more expanded version of that sort of system now. That kind of um, over legislating
Mhm.
system, and as you say, it's arguably primarily for revenue seeking.
The, in in the U.S., I'm not as familiar about legislation in England in the criminal area, but in the U.S., the interest groups that dominate the legislative process are the public uh, bureaucracies, the police, prosecutors, who through their lobbying and campaign contributions and all those sorts of things, convince the legislatures to pass new criminal laws and criminalize all sorts of things that people don't think are wrong, even. But it just opens up more options for them to uh, argue for expanded budgets.
Yeah, yeah, and you've argued brilliantly in your book as well for the fact that um, the police under such a system aren't necessarily. It's not. They're not incentivized to prevent the crimes from happening. They'll just let the crimes happen. Um, Something as simple as maybe prostitution or smoking marijuana or something like that. It's really easy to get your guy. You get them in, the numbers of people you've caught go up, you get a bigger budget
Mhm.
for the next year, whatever. And so the incentive is really to make ridiculous laws, catch people who haven't really committed what we probably properly call a crime, and there's no prevention, there's no incentive to prevent the crime from even occurring in the first place. A proper crime, I mean, like murder, something like that.
Yeah, of course, with bureaucratic budgets, you don't have a market that determines the value of what they're doing. Uh, they have to try to convince the legislature, the budget makers, to give them funds, and so they look for statistics that indicate that they're working hard, that they're doing lots of stuff. Um, and the kinds of things that they have used in the budget negotiations primarily have been things like numbers of arrests and response time. So after somebody calls about a crime, how quickly do you respond to it? So these are things that focus on after the event rather than trying to prevent it ahead of the event. Um, Now, presumably they patrol to prevent crime, but there's they're they're not very effective at that. In fact, in the United States, there's probably three times as many private security officials or officers or whatever you want to call them as public police, and the private security industry is all about prevention, trying to stop crimes up front. But you can't measure how many crimes you've stopped or prevented, and so the police need something they can measure. In the marketplace, people are willing to pay for that security, even if they don't know how many crimes are prevented, because they feel safer and typically are. So we have sort of bifurcated the process. The front end, prevention, is in the private sector, and the back end then pursuit and prosecution is in the public sector.
And of course, historically, private policing has, been more successful than the monopolist system that we have in the West and pretty much elsewhere. But to go back to the law, you discuss merchant law in your book, which I find to be a wonderful example of a private legal system, because it began to grow at that time we're discussing, when the king was beginning to put his fingers in as many pies as possible, but they hadn't quite got round to taking a bit off the top of trade, the kind of law that was developing as the bourgeoisie, the capitalist merchant middle class, if you like, was beginning to develop in Europe. So the tradesmen then developed their own private court system, which seems to function pretty well. I mean, you could expect the same kind of results and judgments universally, right from England down to Italy. Isn't that correct?
Yeah, I'm actually writing a new book on that system, because there's been some critics who have claimed that, of course, the private sector can't have law, essentially, but the development of what most people now call the law merchant or lex mercatoria, not an accurate name, but it's the common name, really starts occurring about the same time, actually, maybe a little earlier, than we start seeing real developments in royal law, like the common law, including the common law. Harold Berman has a wonderful book, if anybody's interested in the development of law and the Western legal tradition. It's called Law and Revolution, I think. And in there, he points out that period sort of between the, in the 10th, 11th, 12th centuries, you start seeing simultaneously the development of a number of different legal systems. Canon law, of course. Yes. Royal law is starting to develop. You've still got the feudal law, manor, the law of the manor,
urban law,
merchant law, and then urban laws. All of those sort of start developing at that time, and there's they're overlapping, competing for jurisdiction. There's a lot of interplay between all these systems.
Yes.
But they're all distinct systems that are developing at that time. And he goes into explaining the consequences of that very well in his book. So I recommend it highly. But the law merchant itself, early as commerce really started emerging, there was always trade after the fall of Rome, but not a tremendous amount. And commerce really started emerging in probably maybe the 800s. We don't have much data from there. Probably the 900s. Lopez describes the commercial revolution as occurring between 950 and 1350. This is the period where the law merchant really starts becoming very visible. Most early on, most of the trade was at fairs. At least the international, interregional trade was at the big fairs, like in Champagne and places like that. Those fairs, when they set up the fair, they would set up a participatory court, a merchant court, where individuals from the various groups of merchants that were gathering at the fair would form a tribunal, I guess you might say. In England, they called them the Dusty Feet Courts, because, in part because you just walk in off the street and get your dispute taken care of, and so you can leave and get back to business. So these were very different courts than the common law courts, and lots of legal scholars recognize this. They were quicker, they were less formal. Their rules of evidence were not nearly as demanding. They were participatory in that the judges were actually members of the communities. I'm finding out that there was also a lot of private arbitration during this development. So you didn't have to go to these courts. You might just take your dispute to another merchant or a couple of merchants and ask them to hear what each side is arguing and propose a decision. So they didn't have to go into the public courts if they didn't want to, whether merchant or otherwise. And merchants could choose any other courts too. They did use the canon law courts quite often, because the canon law did develop a contract law pretty early. There were some things about it that the merchants didn't like rules against usury. But if a contract dispute would be dealt with the way they wanted it to be dealt with in a canon law court, they could use that. Really, equity, fairness, it was the main point of the law merchant, and the canon law in that context as well. So the interplay between canon law and the law merchant's interesting. With the formation of market towns, then you start getting market courts as well. And early on, they were merchant adjudicated courts. Over time, of course, you start seeing the lords who might have a fair on their property taking some control over the fair court, and the local merchants taking more control over the market courts and discriminating then against foreigners oftentimes. And so you start seeing sort of authoritarian activities moving into the law merchant, and so it gradually starts breaking down. Ultimately, many of the rules, of course, customary rules, essentially were codified and taken into the various royal law systems that were developing. I mean, the kings and lords, they wanted the fairs, they wanted markets, so they could collect tolls and
Yes.
any sort of taxes that they might want to collect, and get more control over commerce and so on. So, and they like to buy a lot of stuff too. So they tried to attract these fairs and markets, And so there was a fair amount of competition between different urban and feudal kinds of courts to attract market activities, and that meant essentially adopting the rules from the law merchant. If you're going to attract a big fair, you have to provide a law that the merchant community wanted to be provided, even if the judge happened to be a lord now or one of his appointees instead of a merchant. So the law merchant in various forms really continued all through what we think of as the medieval period and on into sort of modern history. I think there's still a what you might call a pie powder or dusty feet court. Someone told me there's still one in some place in Spain where they meet on the steps of the church, but pretty much all those courts are gone. On the other hand, private arbitration has become very widespread. I suspect that way more than 75% of contract disputes are arbitrated rather than going to public courts today. Yeah. And of course, international trade is pretty much all arbitrated, and so you still get the private process of judging, and of course today in an international contract you can specify the law that you want to apply if there's a dispute. So you could say I want the law of the state of New York or of England or something like that to be used in judging a dispute. But if you don't specify a particular law, then it's still a law merchant essentially that's being applied. It's practice and usage that the merchants are supposed to be familiar with. And so the one thing, the law merchant always looked at the contract first, which is sort of backward from what the common law did for a long time. Common law looked at the process of achieving a contract. The law merchant looked at the contract and said, do what you promised to do. If they couldn't find a solution to a particular problem in the contract, then as a backup, they looked at practice and usage in the relevant market. You could always contract around a rule that might be developing. If you didn't like the rule, they would enforce the contract first. And that's still really the case in international law. They first do the contract, and then if they can't find a solution there, they'll look to what the businesses in that particular market typically do. So we have an ongoing law merchant, and some people argue a rapidly emerging international law merchant. I argue that there's still that every time a new market starts emerging, a law merchant pops up because the market emerges faster than the government can get a handle on it, and so you start seeing the sorts of institutions of a law merchant develop in these emerging economies as well. I was reading an old law merchant manuscript, and the author said it was interesting that as the law merchant was being absorbed and starting to disappear in England, America, the law merchant pops up as soon as the colonies are formed, and they start arbitrating disputes because there might be a court someplace in the colony, but he'd probably take days to get there and that sort of thing. So we saw in the emerging economy of North America a new law merchant, and the same, I think, occurs everywhere.
Mm. Yeah, the Wild West wasn't quite so wild as we typically think. Yeah, so you've just mentioned there, and I think it shows just how brilliant the merchant law was, that it's still very influential in international law and commercial law today. And you've also mentioned there that people will typically want to go for arbitration, especially when it comes to trading matters. They have an expert in the field who will adjudicate the matter. They know they're going to get a really good decision that way. And obviously, even in typical civil disputes, people want to go and settle things outside of the court because they know it will be cheaper. And so I feel that there's definitely a ripe market for private law at the moment. Do you think it's a realistic possibility? Do you think that there's the possibility that perhaps a state in America may secede, or that perhaps within my lifetime we may see a region, or even maybe city-states even perhaps, adopting some kind of private law?
I tend to be a pessimist, but I never dreamed that in my lifetime we would see legalized marijuana in the United States. We're starting to see it. So while it's hard for me to imagine a successful separation from an existing national government by a state or a region, there are some, I think, feasible options that are being advocated and pursued that are interesting. The various places in Central America, there's some sort of institutional entrepreneurs who are pushing governments to allow a city or a region within the country to get rid of all the regulations and all those state-imposed things and really move to a laissez-faire kind of economy. If it ever happens, it's going to be such a boom town that I think you'd get a domino effect, and there'd be other things like that. Well, in a sense, Cancun in Mexico is a little bit like that, in that the developers of the resort area in Cancun made a deal with the Mexican government that they would provide their own security and that sort of thing, and essentially maintain order. And the government of Mexico agreed to sort of hands off. I'm sure they still collect lots of taxes, but it was a relatively reduced burden of the government. So I could see that that kind of thing happening in some place like Costa Rica or Belize, or possibly someplace in Africa. I'm not nearly as familiar what's going on down there, but if that were to happen, I think then we'd see a number of other places doing the same thing. There's all sorts of other ideas floating around the libertarian community, of course, like seasteading.
Oh, yeah.
Yeah, I don't you know, I don't know if if it's in any country's coastal waters, it's not going to work. So you got to find some place that's not claimed by
Yes.
any country, and those places probably are such so far out in the ocean that they may not be economically attractive. I don't know.
Yeah.
Yeah, but it's fun to talk about them.
Yeah.
The
Right.
I even saw a proposal someone made that we should get a few of our really wealthy tech entrepreneurs to go and buy Belize and turn it into a libertarian haven.
Wow.
I don't. Yeah, yeah. They could probably come up with enough money, but it's.
Yeah, maybe.
But that's pretty far fetched. You know, I'm not confident that we're going to see uh, something like that happen. I see a a constant tension in everywhere between centralization and decentralization. So you've got the government that's trying to centralize more and more power, and then you've got entrepreneurs out there coming up with internets and encryption and things like that to move in the other direction. And you know, at sometimes centralizers are winning, and sometimes the decentralizers are winning. But it's hard to imagine the decentralizers really being able to get rid of government at in some area. I hope it happens, but you know, maybe my grandkids.
Yeah. Yeah. I spoke with Walter Block. He said there are probably too many socio-biological barriers to overcome for now, but he said secession is probably our best shot. And if Walter Block says it, then it's good enough for me.
I'm currently visiting at Texas Tech University, and secession is not an uncommon topic in Texas right now.
Really?
Yeah. Probably always there's probably always some Texans who want to secede, but in this area, they're really not very happy with the U.S. government. So, well, that's probably true everywhere too. Right.
Yeah, right. All right, Bruce, I've taken up enough of your time, and I could probably talk to you for days, I imagine, but I have to stop.
Okay.
Thank you so much. It really is an honor for me to speak with you because I'm so very fond of your book and your articles, and I'm very much looking forward to this book you're working on the merchant law. If you've got a working title for that or something, so that perhaps in the future I could link to that.
Yeah, I've got two working titles right now. One is uh, the myth of the law merchant. Uh, there's been there's a one of the law merchant skeptics has an article called "The Myth of the Law Merchant."
I
So,
see.
uh, and then the other one, I don't know if you are familiar with the story, but the title is "Yes, Virginia, There Is a Law Merchant." It goes to it might be too American. There was many years ago an article in one of the New York papers. A young girl had written the editor and asked if there was a Santa Claus, and the editor wrote an editorial saying, "Yes, Virginia, there is a Santa Claus," and that it became the basis for a movie. Actually, it's been a couple of movies that have been done on the topic. So you know, it's something Americans would recognize, but it may not be effective the rest in other places. So those are currently the working titles. I don't know if either one will last, but
I like it. Yeah, well, whatever it will be, I'll link to it. And again, thank you so much, Bruce. I really appreciate it.